Okay, I think we have everybody ready for the next case. So I will call that case People versus Paul Betts. There are a lot of advocates, so let me go through the order. We will first hear from Ms. Zimbelman, who will try to reserve some time for rebuttal, I assume, and then Ms. Ackerman. Then we will hear from Mr. Justian and Mr. Rastusha, and we'll go back to Ms. Zimbelman if she was successful. So, Ms. Zimbelman.
Thank you. May it please the court, Jessica Zimbelman from the State Appellate Defender Office on behalf of Paul Betts. I'm going to try to reserve 10 minutes for rebuttal. A lot has changed in our world since I was last with you a year and a half ago talking about the Sex Offender Registration Act. But when it comes to SORA itself, one thing hasn't changed. People are being arrested and prosecuted for violating an unconstitutional statute. The Gratiot County prosecutor's assertion that there is a simple fix and this court can just strike 3 sections is an oversimplified and improper argument for 2 main reasons. First, striking those 3 sections does not actually fix the constitutional problems with SORA. It remains an offense-based registry with long registration periods up to life. There are substantial in-person reporting requirements. There are problems with the public nature of the website. There's no ability to petition for removal, and there's no individualized assessment of risk. We know that in an ex post facto analysis, a statute is reviewed as a whole in the aggregate to determine whether it is punishment. So all of these things matter. The order of an ex post facto severance analysis also matters. What should happen is that this court first determines that SORA is punishment by looking at its cumulative burdens. Then this court must determine whether it would have to rewrite the statute to make it constitutional, or if some discrete section could be severed. The second problem with the Gratiot County prosecutor's proposal is that it invites this court to do the job of the legislature. We have a long statute with a lot of requirements. Let's call those requirements A through Z. And cumulatively, they constitute punishment. The Gratiot County prosecutor suggests, well, this court should cut A, B, and C, and boom, we have a constitutional statute. But what if the legislature doesn't want or need to cut sections A through C, but determines a new statute with W, X, Y, and Z is what it wants, and that would be a constitutional statute? Or the legislature decides to add A1 and A2. Or has A through Z for post-2011 registrants, but retains A through J for pre-2011 registrants. These choices are quintessentially legislative choices, not judicial ones. It's up to the legislature to decide whether, in making SORA less burdensome as a whole, it wants shorter registration periods, non-public registration, or retains all the requirements, A through Z, but bases those requirements on an individualized assessment of risk. The responsibilities of the legislative and judicial branches do not change just because the legislature fails to act. And I welcome the court's questions at any time.
Justice Zara, I'll start with you this time.
You know, I'm gonna save for rebuttal because I've talked with many of my colleagues. I know they have questions as well. So let's see if there's any time left in rebuttal and if I have any remaining questions. So I'm gonna defer right now.
Thank you. Justice Viviano.
I'm gonna pass for now as well. Thank you.
Justice Bernstein.
The same.
Justice Clement.
I'll start.
Good.
Can you talk to us about what effects would result if our court determines that a different set of provisions or no provisions constitute punishment and thus would conflict with the Sixth Circuit's Doe's 1 decision and Doe's 2 decision? Can you just walk us through what that would look like?
Yes, so in the first instance, if this court decides that SORA is not punishment as a whole, I think that was part of your question, Your Honor. I believe that would set up a conflict and we would file a petition for certiorari in the U.S. Supreme Court. If this court decides to look at individual sections of the statute and finds that some are punishment and some are not, which again would not be the proper way to go about an ex post facto analysis. But if this court does so, and it conflicts with what the Sixth Circuit has said and what Judge Cleland said in his February order, that would probably also result in a cert petition. That's the practical reality of what would happen if this court decides things differently.
Okay, thank you. And do you agree or adopt the arguments put forth by amicus, arguing that collateral estoppel requires this court to adopt the federal court's decision in Doe's 1?
That's a tough question because this court did not order briefing on collateral estoppel, but I did bring it up in my reply brief. I think there are open questions about what would be considered a final judgment. The ACLU in its brief last night mentioned that typically a state court judgment is not final until the appeals are over. So that would conflict with the Gratiot County prosecutor's assertion that these decisions were final back in 2013, when Mr. Betts pled guilty.
Thank you.
Justice Kavanaugh?
I don't have any questions right now.
Justice Markman?
Yes, Ms. Zimbelman, maybe I'm misunderstanding. Can you hear me well?
I can.
Yeah. Ms. Zimbelman, maybe I'm misunderstanding in some respects, but you're not suggesting that we should avoid looking at the individual components of SORA in order to assess the extent to which these are punitive. Because if we find that something less than the entirety of these provisions are troublesome, we will necessarily have to engage in some kind of severability analysis, which you think is essentially substituting our judgment for that of the legislature. Is that the basic proposition that you're urging upon the court?
To a certain extent, yes. I think that it's really important that this court, and necessary under an ex post facto analysis, to start by looking at the cumulative burdens of the statute. That's what the court said in Smith versus Doe. And it's interesting because in the oral argument in Smith versus Doe, the advocating for the state of Alaska was John Roberts, shortly before he was appointed to the DC Circuit. And the justices asked similar questions to what you're asking, Justice Markman. They said, well, what if we only find that one portion of this statute is excessive in Alaska? And John Roberts, it's not to call him the Chief Justice, but John Roberts at the time said, that would be a different analysis. That's a different question for a different day, because for an ex post facto analysis, we look at the entire statute. And so that's what this court should do. If it determines that, we have laid out in our briefing that there are certain things that could be severed cleanly. The geographic exclusion zones, those can be severed cleanly. The public nature of the registry, all that has actually a clause in the statute that says if any court finds this provision, the public nature of the registry, to be unconstitutional, sever it. So there are...
Can I interrupt you for 1 second? I mean, I understand what you're saying. You're saying that some analyses will allow for severability and other analyses will not, but that's precisely the question that I thought you were suggesting is really inappropriate for us to be considering to a certain extent. But you're engaging in the same kind of analysis that I think you would urge us not to engage in.
You're right when it comes down to it, that this statute as a whole, the burden that places on Mr. Betts has to comply with all of these requirements on a daily basis, as does every single other person out of the 44,000 people on this registry have to comply with these requirements. So they can't look at it in a compartmentalized fashion. And that's why we have the ex post facto analysis that we do. And I do believe that the most proper role for this court is to determine that it's unconstitutional as a whole, and perhaps in its opinion could provide some guidance to the legislature about the most problematic portions of the statute from a constitutional perspective. But this as a whole should be struck down as unconstitutional punishment. When the state filed a cert petition in Doe's 1, the Solicitor General was asked to offer his opinion on whether the court should take the case. And the Solicitor General mentioned first, again, that it should be looked at as an aggregate. and that the petitioner, the state in that case, had cited to no other similar statute in the country that combines all of these portions. And so again, the Solicitor General was advocating that the U.S. Supreme Court not address it because of that reason and the rationale of the Sixth Circuit.
Well, your cautions are all well undertaken, and you're right to be sharing those cautions with us, but they don't seem to be inconsistent with our obligation to look at this statute, the Michigan statute, and attempt to the best of our ability to assess what the punitive burdens are and whether or not the statute can be preserved in light of what we find to be the burdens. Am I misunderstanding something basic here?
No, and it is tricky with the ex post facto analysis, how we do that, and then Michigan's law on severability, because the Michigan legislature does want this court to engage in severance to save a statute if possible. So there's kind of and it might sound like I'm making two arguments here, but in a sense I am, because you have the ex post facto jurisprudence and then you have Michigan's severability law, and those can conflict sometimes, and that is a tricky job for this court. But one thing the court cannot do under either of those is pick and choose discrete portions in an attempt to make the statute constitutional when there are many other ways the legislature could choose to go to get to constitutionality.
Well, can I respectfully suggest that I guess I am understanding another area in which I'm arguably seeing some inconsistencies in your approach, and it may be just a misunderstanding on my own part, but you're again right and wise to suggest to us that we need to respect aspects of the severability analysis that would effectively have us undertaking legislative decisions in the guise of judicial decision making. I think that's a good counsel on your part. But at the same time, you warn us about remaining within our judicial parameters, which once again is good counsel. I understood you to suggest that the better thing to do, rather than engaging in some difficult severability analysis, is simply to defer to another judicial body, the Sixth Circuit. Am I misunderstanding you in that regard?
Yes, Your Honor. If I don't mean to suggest that you should defer to the Sixth Circuit. I'm using it as an example of a court that has analyzed Michigan statute. And of course, in the Sixth Circuit, there was no discussion of severability. There was a review of the statute as a whole, and in the aggregate, Judge Batchelder, said it's unconstitutional punishment as a whole.
But I'm also saying you believe that if we disagree with the Sixth Circuit that the problem is as a whole, we're allowed to find a more discrete problem existing here. Is that fair to say?
I think under Michigan severability law, yes.
And when you talk about cumulative burdens, and you've raised that phrase several times, and it's a good phrase. I mean, I don't think there's anything wrong with looking at things in a cumulative way. But when you talk about cumulative burdens, I mean, I had the sense that you were talking about some things that were undeniably burdens upon a SORA defendant, but not necessarily of a punitive sort. In other words, there's lots of impositions upon a defendant that we might conclude are needless or genuinely burdensome or a hassle and don't need to be imposed in all fairness. But nonetheless, that's not what we're looking to identify here. We're looking to identify things that seem to resemble a punitive treatment of a defendant.
I would disagree slightly, Your Honor, because of the Kennedy factors. And some of those factors include whether there are affirmative disabilities or restraints. It can have nothing to do with punishment, but affirmative disabilities and restraints would qualify as a burden. And Your Honor, in your question also asked about whether excessiveness would be part of that. That's another Kennedy factor, and an important factor, especially with Michigan's large registry. So those factors that the U.S. Supreme Court has laid out for us in Kennedy really do get to the cumulative burden by looking at different factors. One of those, of course, is a resemblance to traditional forms of punishment. That's one of the Kennedy factors. And all of those factors, I think they've been well outlined in the brief. They get to all of the things that are problematic with Michigan's SORA, the in-person reporting requirements, the geographic exclusion zones, the public nature of the website, the lack of an individualized assessment of risk, that really gets to this excessiveness prong. All 44,000 people on the registry are assumed to be high risk and in need of this constant monitoring and obligations. So those are all factors.
Can I ask you just one final question concerning one of the specific factors, and that does pertain to the registry? I mean, looking at the United States Supreme Court decision, they seem to conclude that what was involved in the Alaska case didn't impose a sufficiently punitive burden, because what was generally the focus of the registry was accurate information. Is it fair to say that even though the information that's required to be posted in our case is also generally accurate information, there's something different about this when you consider that in place of one or two people being aware of the nature of your criminal background, this has been transformed by the internet to 20 or 30 or 40,000 people who've been made aware? Or is that single factor, in other words, is that single factor something that can truly transform something that would not otherwise be punitive into something that is punitive? Or would it simply be a function of the fact that the people don't like that kind of conduct, and it's not the state doing any transformation into something punitive, it's the ordinary citizenry whose attitudes are accomplishing the same thing?
That's a great question, Your Honor. And I think that the government is doing it, and the effect that this has on people, the general public, matters in the Kennedy analysis. And I would dispute that all accurate information is on the website. For example, the tiering that is published for registrants is not necessarily indicative of their risk. But putting that aside, let's assume everything that's put on the website is in fact accurate information. The fact that the state has chosen to broadcast registrants' faces and personal information on the internet is a problem. In Smith in 2003, the US Supreme Court said this wasn't like shaming or historical punishments because in colonial times there was face-to-face shaming. That is exactly what we have here. And in Packingham, the US Supreme Court recognized that anybody with an internet could become a town crier with a voice that resonates farther than it could from any soapbox. And that's what you see here. Today's shaming are viral videos and cancel culture through the internet. That's what we have with our internet today. And so it is the state broadcasting that all of these 44,000 people are dangerous and should be feared. And then you have the public reaction to that as well. Those are all factors that play into the Kennedy analysis.
Thank you, Councilor.
Ms. Zimbelman, can I take you back to the tension that you readily identify in the ex post facto jurisprudence that wants us to look at the statute as a whole, and the Michigan legislature's clear preference for us to figure out how to save portions of the statute that we can? How do we walk ourselves through that tension?
Well, I think, again, I keep repeating that you look at the cumulative burden, and it's hard to say whether if you take out, for example, geographic exclusion zones, because I will readily admit, again, that those are easily severable. If this court, for some reason, thinks that taking out that one obligation will lessen the cumulative burden to a constitutional level, that could be a way you could sever the statute. But I don't think it's possible for this court to do this without recognizing the cumulative burden that would still exist, and that being all of these in-person reporting requirements, the internet, the fact that you can't petition for removal and there's long registration periods. So,
but that just sounds to me, I mean, I might agree with you, but that's simply saying that the geographic zones are not the only punitive piece of the current statute. You think there are a bunch of other punitive pieces, and it sounds like you think we could consider those sort of, piece by piece and keep the ones that are not punitive and get rid of the ones that are punitive, which does start to feel a little bit like something the legislature's way better positioned to do. So, but I don't, I mean, I'll ask other people the same question, but it seems very complicated to me.
It is very complicated, and I think that's why we're back here 18 months later having the same but a little bit different discussion than we did last March. I think the problem with the severance analysis is just that it gets too far in the weeds for this court to be trying to cut and paste which individual portions are punitive. And it becomes especially difficult if you're looking at the 2011 amendments. And essentially, the Gratiot County prosecutor argues, take a couple of those 2011 amendments and cut them, and then we're going to be okay. And I don't think that's the proper place to start, is trying to get to a constitutional statute. So this court should decide on its own that this is cumulative punishment. And if it needs to go further to really hone in on what it believes are the punitive sections, then the question becomes whether those can be severed. So I don't think you can start from a place of let's cut what we can to get to constitutionality. You start with the place that it's punishment and see if we can save it through severance.
Okay, thank you.
I'll reserve the rest of my time for rebuttal.
Excellent. Ms. Zuckerman.
Miriam Ackerman, ACLU of Michigan as amicus. I appreciate the court allowing us to present argument today. In thinking about how to resolve this case, the court should consider two very practical realities. The first reality is that the state is bound by the Doe's 1 decision on the federal constitutional questions. Now, as Justice Markman and Justice Clement pointed out, this court is absolutely not bound. It is free to make its own determinations on what the federal constitution requires. But the state itself must follow Doe's 1. And of course, Judge Cleland also is bound to follow Doe's 1. The second practical reality is that there's now a class-wide decision in Doe's 2. The state stipulated to class certification because it recognized that with 44,000 people on the registry, and that's more people than live in, say, Mount Pleasant or Muskegon. With that many people on the registry, you need an efficient vehicle to resolve those claims. The state has repeatedly argued that registrants cannot bring cases to protect themselves from prosecution because once the class was certified, that extinguished the possibility of separately litigating the question of whether SORA is punishment under the federal constitution. But the state is trying to do the exact same thing here. The state is trying to litigate the same question at issue in the class action in this individual case. And you can't do that once a class is certified. So those are the practical realities. In terms of what that means for how this court should decide this case, the path that we encourage the court to take is to use the opportunity presented by Mr. Betts' case to decide that SORA is punishment under the state constitution. Not every claim here is part of the federal class action. Mr. Betts' case presents important state constitutional questions that are squarely before this court. Now, the legislature is obviously very attached to the statute, having not done anything in the last 4 years. And I'd like to get to Chief Justice McCormick's question about sort of what's the path you should take? How can you have that conversation with the legislature? And I think the legislature may be waiting for this court to weigh in. Given that posture, what I would encourage you to do is to say to the legislature, you want to keep this law? Okay, but it has to be based on an individualized risk assessment. The reason that all of these things are punishment, this cumulative burden is punishment, is because it's based solely on a conviction. It's punishment to trap 44,000 people into this Byzantine maze of restrictions with no exit when there's no determination of risk. But the state can impose tailored regulatory burdens that are based on individualized risk assessments. So that is the path that the court could take to say to the legislature, keep the statute you're so attached to, but do it based on individualized risk assessments. The court could obviously also just simply decide Mr. Betts' case, through a summary order because it's part of the class action, or it could take the opportunity to really address the intersection of criminal prosecutions and the federal class action, because there are hundreds of these cases in the lower courts, and the lower courts could use some guidance on that. I want to take a few minutes, though, to address the questions around severability, and I think some examples may help. If you think about a particular example, like all of this is intertwined. If you take reporting employment, for example, it matters not just that you have to report employment, but do you have to do it in person? Do you have to do it once a year or 4 times a year? Do you have to do it for life? What are the criminal penalties attached to that? Is it a strict liability provision? All of those things cumulatively, it's not just, you can't separate out reporting employment, it's how do all of those things mesh together? And that's why the legislative choices are important. So the legislature might say, you know, we really want in-person reporting. We think that's important, but that's more important to us than these really long registration terms. So we want in-person reporting for 7 years, once a year, rather than some of the other choices. And so that's the problem with Mr. Restuccia's argument. He's asking you to make legislative choices, and that is the one path that you cannot take. Just to give a hypothetical example, sort of a different version of Ms. Zimbelman's, if you think about, and to Justice Markman's point, these are burdens, but cumulatively they reach punishment. So if you think about, you have like a budget for punishment, 50 pounds of punishment, and in-person reporting is 30, the internet is another 20, lifetime registration is 40, something like that. You add that all together, we're way over our budget. There are lots of ways to get down to 50 pounds, which is the amount of burden you can impose and not be in punishment land. But in order to do that, that's a legislative choice. Which deductions do you want to make? So that's the path the court cannot take.
Thank you, Ms. Ackerman. Let me see if anybody has any questions. You have used up your time, but I'm going to ask the group. Justice Bernstein, you are unmuted, so if you have a question, you can ask it. Anybody else who has a question can unmute themselves. Thank you, Ms. Ackerman.
Thank you.
Mr. Justian.
May it please the court, can you hear me okay?
Yes.
Good. Charles F. Justian on behalf of the people of the state of Michigan. Mr. Restuccia and I are going to divide our time. I'm going to endeavor to talk about ex post facto, and Mr. Restuccia will talk about the severance issue under MCL 8.5. So in 2011, the Michigan legislature adopted 2 bills, or I should say passed 2 bills that amended the SORA. And yeah, there were a lot of amendments to SORA, and there's no reason to believe that further amendments might not be forthcoming. Whether or not the legislature is waiting for this court to act, I have no clue. I don't know. Mr. Restuccia may have something to say about that, but I have nothing to say about that. In passing these bills, it was a near unanimous decision. The entire Senate voted for it. Over 100 House members voted for it. There are actually 2 bills, as I indicated. One had 4 dissenters, and the other had 6 dissenters. The entire state, of course, elects these people. And to my knowledge, not a single one of them was challenged by the electorate for voting in favor of SORA. We now have 3 judges at the 6th Circuit who say that it's an ex post facto law and it can't be enforced against people like Mr. Betts. In making that ruling, it did so based on a falsehood. And that falsehood, and I'm going to quote it here from its opinion, is this. The court says, as in Smith, the legislative reasoning behind SORA is readily discernible. Recidivism rates of sex offenders, according to both the Michigan legislature and Smith, are frightening and high. Michigan legislature never said that. Where that comes from is the Smith case. The Alaska legislature indicated its findings that sex offenders pose a high risk of reoffending. The U.S. Supreme Court wasn't weighing any kind of statistics or anything, or going behind them or deciding whether or not they were good, bad, indifferent. What it said was the Alaska legislature could conclude that sex offenders pose a high risk of reoffending because there were statistics or empirical evidence that supported that. And it cited two studies which are not attacked. What the defense attacks is this study out of a different case, a plurality opinion, also written by Justice Kennedy, which is not included in the Smith case at all. But what's really important to this court, I think, is that those studies have no bearing on Michigan's statute, because the Michigan legislature said its finding was that sex offenders pose a potential serious menace and danger to the health, safety, morals, and welfare of the people, and particularly to children. Now, posing a potential serious menace is a far cry from posing a high risk of reoffending. And when I studied the statistics, and it's all laid out in our brief, and obviously I don't want to try to go through all that in an argument, but from the statistics that I read, and not only the ones that were cited by the U.S. Supreme Court, but the other statistics that I read, even those that are used by the defense to attack Michigan's SORA, support that finding. Now, what the Sixth Circuit did was it used the erroneous finding, the one from Alaska, the one that the U.S. Supreme Court was discussing, and imposed that onto the Michigan legislature. And it was very interesting to hear the arguments of Ms. Zimbelman and the amicus that seems to suggest that what the legislature says is so important. And this court shouldn't try to judge what it says and shouldn't rewrite the statute and so on and so forth, even though the case or the statutory requirement for that is clear. But again, I'll leave that to Mr. Restuccia. I do agree that what the legislature says is important. And what it said was, as I said, was that they pose a potential serious menace. And all the statistics support that. So when you recognize that the Sixth Circuit's opinion, the foundation for the Sixth Circuit opinion is based on that false view of what the Michigan legislature found, that it was that the Michigan legislature supposedly found that the risk of reoffending is frightening and high. I think the entire decision has to collapse, and I don't think this court should follow it. Now, I go through in the brief, I go through the 5 factors that the Smith court talked about. Nobody's challenging that those are the factors this court must follow. But we can't lose sight of the fact that it's the defendant's heavy burden to show the clearest proofs that those factors would support that the statute is actually punitive. Not punitive in the terms as Justice Markman talked about in burdens, because it can be burdensome. Also, this idea that it doesn't contain individualized risk assessments, that was completely rejected by the U.S. Supreme Court in Smith. I don't even know why we're talking about that. So,
Mr. Justine, I'm going to interrupt you and see if my colleagues have questions for you. Thank you very much. Okay.
Yes, thank you.
Justice Zara?
No questions at this time. Thank you.
Justice Viviano?
I have no questions.
Justice Bernstein?
No questions at this time.
Justice Clement?
No questions. Thanks.
Justice Kavanaugh?
No questions.
Justice Markman?
No questions, no, thank you.
Well, I have no questions at this point either. So let's move on to Mr. Restuccia. People might have some questions for him. We usually do.
Yes, thank you, Your Honors.
May it please the court, Assistant Attorney General Eric Restuccia appearing as amicus on behalf of the Gratiot County prosecutor. The people and the state have been defending this law for many years now. This case is 8 years old, and the federal suit also started in 2012. Mr. Justine and I divide up the labor for the 2 basic questions here. 1, whether the statute is constitutional, and 2, if not, whether it can be salvaged. And I'm here to focus on the latter point. While I continue to insist that the statute as a whole is constitutionally firm, the only way I can see this court writing an opinion to say it's unconstitutional as an ex post facto violation would be to identify the ways in which it extends beyond the federal SORNA, which has been found to be constitutional throughout the country. If unconstitutional, if Michigan's law is unconstitutional, then this court is directed to follow MCL 8.5 and to sever the unconstitutional portions. And those would be the three significant ways in which Michigan's law extends beyond the federal SORNA. So this court would be then directed to excise the in-person reporting requirements for temporary residence, electronic or instant messages, or regular use of a vehicle, to excise the public nature of the tiering, and to excise the student safety zones. Now, there are three principles underlying this conclusion. First is that the amendments to the SORA that the legislature enacted in 2011 were, by all accounts, designed to make Michigan's law SORNA compliant. There are currently 22 jurisdictions which are compliant, including Michigan. Second, every controlling federal appellate decision that has examined SORNA in the face of an ex post facto challenge has affirmed its constitutionality in the face of that, including the Sixth Circuit as of August 26, 2000. And the case was Willman versus United States Attorney General 972 F3rd 819. And third, Michigan law has a preference for severance. If you look at the 8.5 law, it talks about the manifest intent of the legislature, and it directs the court to give application or give effect to the portions of the act that are constitutional. The Blank case, the lead opinion from Justice Kelly, was that the general rules favor severability over striking down an entire act, and provided a two-step analysis. The first step, looking at whether the unconstitutional provisions are independent. And we've heard from Mr. Zimbelman that in significant ways that she does think that they are independent. And second, can the remainder of the act, is it otherwise complete and can be given effect? And the answer here is yes. The key question is whether it's clear, this is the language from Blank, whether the legislature would have passed the statute had it been aware that portions therein would be declared to be invalid. There is no way the legislature in 2011 or today would rather have the whole statute fall for more than 30,000 pre-2011 offenders rather than excise these three parts. We're talking about 4 statutory provisions for the student safety zones and 64 words. That's it. I provided Exhibit C, which is my red line of what I'm proposing could be then the severance action of this court. And in fact, it's not like there's no templates for even the action I'm suggesting here. If you look at the February 2020 district court decision, it had 2 parts. One was the ex post facto analysis, and that's what we've been focusing on. But it also had a prospective analysis for all registrants in which it found 9 distinct provisions constitutionally infirm, 5 for vagueness reasons and 4 on First Amendment grounds. And it struck all of those 9 provisions. And the plaintiffs in that case agreed that the statute was severable. Well, that's the template for this court's, the appropriate course for this court to take now. And with respect to the collateral estoppel and race judicata issues, I'm prepared to address both of those. I think the only thing I want to say about that is the 2016 claim about collateral estoppel has not been raised. And I think this is one of those instances where the court should be careful about its waiver doctrine, because it's not like this is the interpretation of a statute. What the argument is advanced to do is to bar this court's review of the constitutionality of the statute. And with respect to the 2020, again, the argument is trying to take the opportunity for this court to review the severability, a state law question, away from this court. And I don't think either of those claims is well founded, but I'm prepared to address that at length, or if the court has questions with respect to either of those arguments.
Okay, let's see what questions we have. Justice Zara.
No questions at this time, thanks.
Justice Viviano.
Mr. Restuccia, you'll be glad to know I have no questions for you.
But you guys are going to wrestle later, right? I hope.
at least arm wrestle.
Yeah. Justice Bernstein.
Good morning, Mr. Restuccia. I have to say, I always enjoy it when you come before the court. I love your passion and your energy and your enthusiasm. So it's always a pleasure to have you come before us.
Thank you, Justice.
If you could do me a favor, could you just comment on what has been argued before about the notion that, you can't take, if something is unconstitutional, you can't then kind of try to make it constitutional by eliminating certain parts. And I'm just wondering if you could kind of respond to the ACLU's argument that they kind of put forth, that if an element is unconstitutional, the whole thing becomes unconstitutional, and you have to start from the basis of kind of that perspective.
Well, I think the question is on what basis this court's going to conclude that the statute is unconstitutional. And so I'm taking the federal SORNA law as kind of a safe harbor for me. Now, this court's not bound to conclude that even the federal SORNA law is constitutional, but I think that there's a very compelling argument to be made that it is. And if the court believes that, and of course that was the design of the 2011 statute, everyone agrees that what the legislature was trying to do in 2011 was to make it SORNA compliant, but it extended it beyond the 2011 law. So when you take those two principles and then join them together, which is you're directed by the legislature to give effect to the constitutional applications. And if you agree that a federal SORNA law is constitutional, and I think that it's indisputable that the 2011 design was to make Michigan law SORNA compliant, then the next question is, if you strike the provisions in which Michigan law significantly extends beyond the SORNA, is that within the competence of this court? And I think that's exactly what the legislature has asked. In fact, I think Ms. Immelman, when she said, well, yes, you could eliminate the student safety zones, they are distinct provisions and they're kind of standalones, or you could eliminate the public nature of the tiering. That's two of the three things I'm suggesting that should be struck. And then the question about how this is the way in which the law significantly extends beyond Michigan's, or sorry, the federal SORNA. I mean, we have a couple of different indications. In fact, Ms. Immelman, on page 46 of the amicus brief, cites the United States Solicitor General opposition to our petition for certiorari, identifying the same exact three components that I'm suggesting should be severed here. And if you look at the Sixth Circuit analysis, now the court didn't make any references to federal SORNA and its constitutionality and the differences between the laws, but its analysis focuses in on these very same three components that I'm talking about. The public nature of the tiering, because of the concern about the lack of individual determination and that information then being published, or the student safety zones, which I think played a prominent role in the analysis, particularly with this map of Grand Rapids and the lack of places where people could live. I mean, if you eliminate the student safety zones, if that's the action that's taken, which is discrete portions, the vast majority of the equities that Mr. Betts and others are pressing forward. Now, I don't think Mr. Betts necessarily has all the equity because he doesn't live in Grand Rapids. Muskegon's not the same kind of community as Grand Rapids. Nonetheless, the power of the claims regarding Michigan's registry, I think, dissipate radically. In other words, if this court took the action to strike those three provisions, it would make a constitutional statute and it would be consistent with what the legislature has directed this court to do.
Counsel, thank you so much. And like I say, I look forward to your next argument.
Thank you, Your Honor.
Justice Clement?
Just a couple of things. Mr. Restuccia, of your list of three things, the first one is in-person reporting. Are you suggesting that if we were to sever portions of this, that you would be okay with us severing in-person reporting completely?
No, there are 7 different in-person reporting obligations. Michigan law extends beyond federal SORNA in 3 ways, for 3 of those 7.
3 of the 7.
So the 3 are temporary residence. So if I'm going to be in a residence for more than 7 days, under Michigan law, I have to appear in person within 3 days. In federal law, I can notify by mail. If I'm going to have a vehicle, I'm going to change the use of my regular use of vehicle. Under federal law, I don't have to appear in person within 3 days. Under Michigan law, I do. If I'm going to have a new internet identifier or electronic identification, new email identification, I have to appear within 3 days under Michigan law. I don't under federal law. With respect to employment and residence generally, I do have to appear in person within 3 days under Michigan law and also under federal law. So that I'm talking about striking those three ways, those in-person obligations with respect to temporary residence, electronic or instant messaging, or regular use of a vehicle from Michigan law, because that's the way it extends beyond the federal SORNA. But the other reporting obligations would remain in person, consistent with SORNA.
Okay. And then you commented that I believe in February of this year that the plaintiffs agreed that the statute was severable as to 9 portions. Those 3 in person that you just, 3 of the 7, were those part of it or
No,
separate?
so if you look at the February 14th opinion from the Federal District Court, it found that the prohibition on working within student safety zones was unconstitutionally vague. Loitering, residing, the requirement to report all telephone numbers routinely used. These were different provisions. These were, that's 3 or 4 of the 9. So these aren't overlapping.
Okay.
These are, well, yeah, no, as I look at it, but if you look at the district court opinion, this is for all registrants. This wasn't an ex post facto analysis. This had to do with vagueness challenges to particular provisions. So my point is that it's not that hard to take discrete provisions and to strike them. And Judge Cleland, now his opinion has not become a final judgment. And when it becomes a final judgment, then the state will be subject to this injunction regarding these 9 provisions. And this isn't backward looking. This is for all registrants. But my point to you is that the court did not strike down the statute and say it's not severable. And the plaintiffs did not make the argument that those 9 provisions would require the court to strike down the entire act. It could then just strike and find unconstitutional those 9 discrete provisions.
Okay. And then one final question, and I'm sure the Chief Justice is probably going to ask this, but in case she doesn't, I'm going to ask. It sounds like you've identified a way to do this and have laid this out. It sounds like, hearing from amicus and sister counsel, that they think that there's a way for the statute to be written. Why is it left to the court to do this? There's been plenty of time. Why has the legislature not taken input from very involved and capable attorneys that have looked at this and I think have reached a lot of agreement on this? Why is it coming to us? And why are you asking us to do it when it seems like these decisions should be made by the legislature?
Well, it's not really me who's asking in a way. It's the legislature under 8.5 says, and they've already told essentially the courts. So I'm just saying, this is what the legislature has told us all to do. I mean, I'm kind of pointing to the law. So I'm not the one, the engine behind this. It's really the legislature's laws that's the engine behind it. And they say a couple of things. They say manifest intent. Now, I think it's true that there are probably different ways that this could be carved up and to be made constitutionally sound, right? But the last significant substantive act that the legislature took on this law, it was in 2011. Everyone understands that the entire purpose of the law was to make it SORNA compliant. We're one of the 22 jurisdictions. We receive federal funding. That's what the legislature wanted. So now we know what their manifest intent is. We want a SORNA compliant statute. Well, if that's the right understanding of what their intent was, and you can give a constitutional application, the next question, which is this court's case law, is would the legislature have passed that statute had it been aware that portions therein would have been declared invalid? Student safety zones, public nature of the tiering, in these 3 different ways you have to appear in person. I think it's unmistakable that the legislature in 2011 or now would much rather that than to have 30,000 offenders come off the registry entirely. It would go dark. If this court doesn't sever the statute and that judgment goes into effect, or you make your own decision independently and say it's unconstitutional, it's an ex post facto violation, and it would cut almost 3/4 of the registry off. Now, the idea that the legislature would want that to happen rather than have these 3 sections severed, I just don't, that's not a hard question. I think that's probably the most straightforward. And the question is the intent sufficiently clear? I think it is. I think in 2011, what the legislature was attempting to accomplish was to make a SORNA compliant statute. So consequently, this court has sufficient guidance from the legislature about what its intent was in 2011, and that then obliges the court really to follow 8.5 and to give effect to the remaining portions of the applications of the act.
Thank you.
Justice Kavanaugh?
No questions for me.
Justice Markman?
Mr. Stusha, thank you for your thoughts. Am I correct in my tentative thinking that if this court was to engage in a very closely focused and discrete analysis of the individual provisions of Michigan's SORA and eventually reaching some disagreements with the Sixth Circuit, we would not be contributing to chaos or division or confusion, But in light of the status quo right now, which is effectively the decisions of the Court of Appeals in this regard, we would at least arguably be contributing to a resolution by highlighting and minimizing, at least arguably minimizing the differences with the federal court. Am I looking upon the larger picture here correctly when I say that?
If I understand the question correctly, I think that's right. And I think there's 2 points. Let's say this court, in fact, this is Justice Clement's question. Let's say this court thought Michigan law was perfectly constitutionally sound and that there was no need for any severance whatsoever. I think this court would be duty bound to reach that conclusion in the wish of that decision. And we have been pressing that as an argument for years and years. If the court reached that conclusion, I think the solution is clear because Ms. Zimmelman's already made clear, I think she would have an ethical obligation to file a petition for certiorari. And I would recommend to Mr. Justin that he would acquiesce to the United States Supreme Court taking the case, because that would then provide an opportunity for the United States Supreme Court to explain the differences between the Sixth Circuit decision and the Michigan Supreme Court decision. So that's one aspect. But if you're really asking the secondary question, my focus, which has been severance, there is no question that the final arbiter of Michigan law on severance is this court. In other words, when we were talking with Judge Cleland in the hearing, because in February we had asked for a certification on this issue. And Judge Cleland, I mean, the case has been kicking around for a long time. So I think in fact, I think his footnote says the very thing that horse has left the barn about judicial economy. So he didn't. But one of the things he did say that I think was critical for this court's to answer this question is that he noted that if this court reaches a different conclusion on severance, because he was sensitive to the fact that this court is ultimately the final arbiter of the issue of severance, he said, would it be so hard to file a 60B motion, Mr. Freilich, the counsel for our office? And he said, no. He said, it's not very hard for me I could just conform the judgment, couldn't I? And the answer is yes. So that's why he didn't certify, because he knew that if this court reached a different resolution on severance, we could circle back and say, Judge Cleland, the federal district judge, we have gotten a resolution and it's different. And of course, he understands that on those questions, he's not the final arbiter. It's not a federal constitutional question. This is a question of the proper application of 8.5 under Michigan law. Now, on the issue, let's say you said the federal SORNA was perfectly constitutional, and that's a constitutional statute. Obviously, the issue about the constitutionality of the law on that point would be subject to further review. But the issue about what should be given effect and what the legislature's manifest intent was, this is the final stop on that train.
And do you have any further cautions for us as we engage in that severance analysis in order to ensure that we remain on the right side of legitimate separation of powers concerns in that regard? I mean, you've expressed thoughtfully your concerns as to what the underlying intention of the legislature here must necessarily be in light of the context and the history that you see. But are there any other precautions you would urge generally upon a court undertaking what could be a fairly complicated severance analysis?
Well, I think the points that there are cautions. There's no question. And I think that Ms. Zimmelman and Bachman have identified some of the concerns with respect to it. But at the same time, the very provisions that we're talking about are discrete. I mean, if you look at the comparative analysis that the district court did globally, and finding its 9 provisions that it struck, where there was no dispute about severability, it's not so different from what's being requested here. And then, of course, part of what differently postured the district court case is that there was some language in the Sixth Circuit opinion that said essentially that the provisions of 2006 and 11 as a total must cease, which constrained the district court in its ability to review these questions. In other words, if you look at, if it's true that 2006 and 11 had to totally come out of the statute, well, that's a very hard statute to resolve. But the Sixth Circuit didn't purport to engage in a remedy analysis. And in fact, I do think this too about this court. In reaching the issue of severance, it has to reach the constitutionality of the question first. What the Sixth Circuit didn't do, which I think would be incumbent upon this court to do, is to explain where, why, and not to say, well, this is unconstitutional. And then, but what less than that would be fine? No guidance. I mean, if it has ultimately the conclusion about how we can then tease out what parts come from our knowledge of federal law and its substantive analysis, but it wasn't self-conscious in its description. So I think this court, in doing that, it should be careful and kind of identify what makes this constitutionally infirm. And in doing that, you've identified, and I think it's going to match up. I mean, I'm starting from the premise that the federal law is SORNA is constitutionally sound. Once you know that, I think everything else falls in place.
You will take no offense, I hope, Mr. Restuccia, if I say that when you appear before this court, you wear many hats. I'm never quite sure what kind of public representation you are engaging in at the time.
I always try
Thank
to
you.
take the government's position.
Thank you.
Mr. Restuccia, I have no questions for you at this time. I think there we go back to Ms. Zimbelman.
Thank you, Your Honor. Make no mistake about it, Mr. Restuccia is asking this court to enact SORNA from the bench, a statute that the Michigan legislature has never chosen to enact. And in fact, they have introduced one bill in the last 18 months. And guess what? It's not SORNA. And so I think that that's really important when you look at this piece by piece analysis that Mr. Restuccia is suggesting. There's further inconsistencies within his position too. Why only are those three portions of the immediate in-person reporting requirements unconstitutional punishment? Why is it having to immediately report your schools, your work, and your housing? Why aren't those considered punishment or shouldn't be part of the analysis? Mr. Restuccia is picking things out of the air to try and get this court to come up with a constitutional statute. And again, the proper ex post facto analysis is to start, this court should determine what is punitive. And cumulatively, it's a punitive statute. And I think one of the briefing, I believe that the Muskegon County prosecutor said, well, the reason that having to report your house and your job and your schools might not be punitive is because those don't change very often. But I think that is an argument that is out of touch with what's really going on in the world today. People move. If anything, we've learned from this pandemic, you know, a sex offender would have to report that they're working from home now. What if they lose their job in this economic crisis we're facing? They would have to go report that immediately. What if they get in a car accident on the way to reporting and they have to borrow a friend's car? They would have to report those changes. What if they decide to take advantage of some time to go to school and get a new email address? All of those would have to be reported within 3 days. And so the distinction between these three things and these other four things, that's the quintessential legislative choices that this court should not be parsing out with such fine detail. This is really the job of the legislature to determine what is going on here. And also, when it comes to SORNA, Mr. Restuccia calls it a safe harbor. I don't think that that's a fair assessment. To start with the presumption that this is a constitutional statute. It's not at issue here. Michigan has never enacted it. And in fact, 32 states have chosen not to enact or be SORNA compliant for a variety of reasons. But cost and the level of requirements come within those. So SORNA really is a red herring here that this court should not take into account when it's doing its own ex post facto analysis of Michigan's statute. I welcome at any time any questions someone might have for me. And also just the point about we don't have a choice here. This court, the choice for the court is not sever these three sections or the entire statute will fall and 30,000 people will be off the registry. That's not a black and white choice for this court. The legislature can act. If this court finds this statute to be unconstitutional and the court wants to enact a sex offender registry, then it can do so. And then there would be no darkness, if you will. This is the legislature's job to enact a constitutional registry. And again, this court could provide guidance to the legislature. If they want all these requirements, maybe this court could suggest that an individualized assessment or a risk-based registry. The ACLU points out in their brief, there are 15 states that have risk-based registries. That might solve all of this. So this court.
Do you share that? Do you share the ACL's view, Ms. Zimbelman, that if there was an individualized risk assessment, the statute would be constitutional?
Most likely, yes, absolutely, because it really gets to that excessiveness point. Because right now, as can be seen in the Safe and Just Michigan amicus brief, we've flipped it on its head: risk versus tiering. about 3/4 of the registry are considered low-risk individuals, but yet 3/4 of the registry have the highest tiering, which means the highest obligations and lifetime reporting. They have to follow this for the rest of their lives. So perhaps if we could actually target this registry and focus it on high-risk individuals who might actually pose a risk to public safety, that would be meeting the manifest intent of the legislature and actually perhaps keep our Michigan citizens safe.
Let me see if anybody else has any additional questions for you. Justice Zara?
Questions, thanks.
Justice Viviano?
No questions. Thank you, though, for your presentation today.
Justice Bernstein?
Council, good morning, and I want to thank you as well for your presentation. I just want to ask you a more pragmatic question. The result, though, in terms of based off of your argument, would be, wouldn't the registry ultimately still go dark?
Yes, possibly. If this court declares it to be unconstitutional, I'm sure there could be some time limits put in, to try and get the legislature to act.
But you understand, but it ultimately, though, there would be a certain parameter period where there wouldn't be a registry.
Potentially, it would depend on the wording of this court's order and opinion and how fast the legislature choose to act. We know they can act fast when they want to.
Council, thank you very much.
Thank you.
Justice Clement?
No questions. Thank you.
Justice Kavanaugh? No?
No, sorry.
Oh, sorry. Justice Markman?
Thank you, Ms. Imbleman. I have no more questions.
Okay, Ms. Imbleman, anything else you want to say before we conclude?
No, thank you.
Thank you very much, all of you, for your presentations. The case will be submitted.